Okay, good afternoon. This is Harish Narasappa from Samvad Partners, and I have my partner Poornima Hatti as a co-panelist. Let's just give a few minutes for others to join in, and we should be able to start. Good afternoon, everyone again, and welcome to this webinar. What we hope to do today is discuss some of the concerns that have arisen from the strange circumstances that we are all going through. And what we want to do today is identify some of those concerns that are affecting many of us on a day-to-day basis, and then look at what the law states, particularly the law around force majeure. What we propose to do today, between Poornima and me, we will take about 40-45 minutes, and then we'll open it for questions and comments that others may have. We have scheduled 1.5 hours on this webinar today. Hopefully, we should have enough time to discuss everyone's questions and concerns. If there are any other questions that we cannot discuss, please feel free to reach out to us outside this webinar by email, which is the best option in the current circumstances. So what we will do today is look at what are some of the issues that have arisen following the lockdown in our country, and prior to that, the lockdown in different countries, which has affected businesses in this country. So instead of going in seriatim, what I propose to do is identify the various aspects that arise for any business, for any organization. What are the challenges that we are facing today because of the coronavirus and the lockdown? Now, if we look at any business organization, we should be able to identify. About 4 or 5 aspects that are important to any organization. And what are these 4 or 5 aspects that are important? I think most of us know it, but we need to categorize that in a way which helps us analyze the force majeure impact. The first one is people. So all organizations have employees, they have consultants, and other kinds of people who are dependent on the organization. It could be contract labor, it could be vendors who are dependent on the organization, that is directly. So people is the first aspect. The second is financing. So every organization has different modes of financing. They could be raising loans, they could be raising equity, or some other form of financing, either banks or through other institutions. Then the second aspect of the I'm sorry, is everybody able to hear me? Because I'm seeing some people asking what time is the webinar starting. I'm hoping that everybody is able to hear me. If anyone is not able to hear me, please send a message on the chat and we should be able to talk. Okay, I think I've got enough answers already, so I'm continuing. So we dealt with people, we dealt with financing from different perspectives, that is either equity, loans, or any other form of financing. Then we have customers for all organizations, then vendors. So as an organization, all of us are dependent on other organizations who may either provide services to us, or raw materials if we are a manufacturing entity. So there are many vendors with whom we have a relationship. Then there could also be a relationship through various supply chain mechanisms. For example, we use courier services or logistics services regularly. They may not be directly our vendors in the sense that they don't provide any direct input to what we do, but we are dependent on the supply chain and logistic services for continuing to function. And then the last aspect is the place of work. It could be a factory, it could be an office. So using whether it is leasehold or freehold, or we are dependent on others to provide, for example, now we have WeWork and CoWorks and institutions like that. So we have premises as the other aspect. Now, the lockdown that all of us are experiencing affects each of these different limbs of an organization. It is not as if it's only one limb that has been affected and we are somehow able to deal with it, but all limbs are affected. Now, people, because we in the VC world and in the startup world, we use a phrase very often that the most important thing in any startup is the people. And in fact, many people say the only important thing in a startup is its people. So how do we deal with our people? So there are employees, there are directors, there are investors, there are consultants, and various different people. Now, in a situation like this, what are your obligations towards the employees? Obviously, every employee has an employment contract that the organization would have signed with that individual, but will not in the current circumstances. How will the employment contract govern the relationship if the lockdown continues for a while, or if because of the financial implications there is a problem to meet various obligations? Now, Poornima has done a lot of work on employees and the relationship between employees and the organization. Now, I would like to point out one aspect before I request Poornima to comment on the various issues here. In most employment contracts, there is no force majeure clause, right? Typically, organizations do not include either in their employment contracts or in their employment policies a force majeure clause. In an employment contract, there is an obligation to work by the employee, and there is an obligation to make payments by the organization. So there is a salary payment, there is a bonus payment, there's a gratuity payment, and many other aspects. As I said, there is no force majeure clause in an employment contract. But in a situation where the organization is struggling, what are the obligations of the organization? The simple answer is you're obliged to make payments and continue making the payments as long as the employee is able to work. Now, in the circumstances where there is a challenge of how work is to be carried out, how do we deal with this situation? I'll ask Poornima to comment a little bit on this issue before we move on to the next stage. Poornima?
Thanks, Harish. So, I mean, as everybody would know, the Indian employment law is divided such that there is a bucket of employees who would fall within the definition of what under the Industrial Disputes Act is called as workmen. And the other bunch of employees, typically senior management, those folks who have managerial responsibilities, earn a little bit higher, would be categorized as non-workmen. For non-workmen, the presumption always has been that they are able to negotiate a contract. The social responsibilities of the law are lesser. So there's almost entirely a contractual relationship. Whereas for workmen, the Industrial Disputes Act and a plethora of case law, judicial precedents over a period of time, as well as specific state mandated legislations such as the Shops and Establishments Act and other specific trade practices which each state has put together, makes sure that they have more robust protection. So the terms of termination are not entirely contractual, the terms of work are not entirely contractual. So in these times, what has happened is under the mandate of the various disaster management roles that have arisen in the context of the COVID-19 situation, we have had guidance that has come from various departments of the government of India, again, coming directly from the powers of the National Disaster Management Authority. Now, if you read the language of these advices or notifications, it could be seen as they are advisories and not mandatory, where they clearly stipulate, as Harish said, that there should be less termination as far as they are working. They should be allowed to work. And even if there is any situation because of the COVID-19 situation, there should be no termination. We've actually seen a specific letter that has gone out from the Joint Secretary of the Ministry of Labour and Employment to all employer associations as of March 20th, 2020, which should very clearly says, there should be no adverse action, particularly termination of employees taken by any employer associations. The government of Karnataka also has issued a very specific notice along similar lines. So in these circumstances, we don't know how long the situation will last and how deep the pockets of each employer may be. And as we have seen, employment agreements don't have force majeure clauses. What we're really looking at a situation is if an employee is able to carry out his or her work. Now, there may come a time when an employee may not be able to carry on work. And then what happens, and then what the advisories say and how can they be construed is something for each employee and employer to look at. So the point that I want to make is, insofar as workmen are considered, please be careful. You'll have to follow all the local legislation, look at the situation and see what the guidance is. Insofar as the senior employees are concerned, people who are with a more discretionary role, then the contractual relationships that work between the two stakeholders will come into focus. The other thing that you want to keep in mind is our learning from the HIV epidemic stage or HIV discussions that happened much early in the late 80s, early 90s, was that employee history in terms of medical history is now considered sensitive data, personal information, although the PDP bill is still pending. And from what we have today, this would be sensitive information. And if the employer has access to this, we must treat it as sensitive information. Just because somebody contracts a disease, and in this case, if they do contract the coronavirus, that will not be grounds for termination. In fact, the guidance right now is to extend as much possible help, ensure that insurance and other sickness-related benefits are extended by employers. So we will look to see what kind of innovative solutions employers, how long it will last. So these are a few points that I wanted to make insofar as employee-employer relationships. We'll take questions as they go along. Thanks, Harish. You can continue.
Okay, thanks, Poornima. So the only point that I would like to make is in terms of relationship between the employee and the organization, apart from the employment contract, as Poornima mentioned, the various laws of the country govern the situation, and to the extent that the contract is inconsistent with the law, then the law prevails and not the contract. Now, this is slightly different from the relationship you will have with other organizations, which we can talk about a bit later. So it is important to remember that when you're trying to deal with your employees as an organization, whether you are asking them to take salary cuts or reduce work hours, etc., you need to remember what the law says, particularly in the context of what's happening now and any guidelines and advisories that the government has issued. Moving on, now the second issue is financing. I'll deal with this first and come to the come to vendors and customers at the end, because that's really the most contentious, I suppose, in the current context in terms of contracts. But just in terms of financing, most of you would have seen that the RBI has requested the banks to give a moratorium of 3 months on repayment of loans and things like that. There is still a lot of confusion about the moratorium, because except SBI, last I checked, no other bank has actually come out and issued any policy note on whether they are following the RBI's suggestion. So we'll wait to hear on that specific issue. But generally, a pure financial obligation, when I mean a pure financial obligation, that is an obligation to pay money, whether as a borrower or whether as a lender who has agreed to lend money, or as an investor who has agreed to invest into a company. So just the obligation to pay is generally not covered by the typical force majeure clause, because the argument is that a force majeure clause does not really prevent anybody from meeting a financial obligation. Now, there's a distinction here. I'm only talking about a very subtle but important distinction that we need to remember. I'm only talking about a pure financial obligation to pay, assuming all other things are okay. For example, you were supposed to receive a service, but which you have already received, and the only thing that is remaining is your obligation to pay. You cannot take the excuse of COVID-19 to say that you're not able to pay unless you show that the entire banking system is shut down and it is impossible for you to make that transfer of money. Now, as we know, banking systems in most countries are working. Even in India, the banking system is working. There is a sluggishness in the system because the banks are also working, many of them are working from home. There is not full-time service that is available. So there may be a sluggishness in the system, but the ability to make payments has not been lost currently. So those of you who have to meet financial obligations by making payments, you cannot use these circumstances as an excuse. This is a thumb rule. There could be exceptions where other things may apply, but we should keep this in mind. It's a different point that some financial documents, either loan documents or investment documents, may have something called a material adverse effect clause or an event of default clause. So a material adverse effect clause normally may include clauses which say that if the overall economic scenario is adversely affecting the business of the company into which the money is coming in, then the investor may have retained the right not to invest. Now, if such a clause exists in the contract that may be applicable to you, then it is possible that your obligation to pay may be excused, but that depends purely on the terms of the contract. And note that this is not your standard force majeure clause. It is more of a material adverse effect clause where there is a lot more discretion as to what happens both in the determination of the material adverse event plus in the consequence of that material adverse effect. So this is different from a regular force majeure clause, which we will come to in the last two limbs that I mentioned, which is customers and vendors. Now, most of our relationships with customers and vendors are governed by contracts. Now, in a contract, as all of us know, there are two promises. Somebody is promising to deliver a service or deliver a good, and then the other party has an obligation to pay for those services or goods. Most contracts are, something like this. There could be variations. There could be a combination of service and goods. There could be a continuing contract. There could be maintenance contracts, etc., etc. But by and large, these contracts fall into two buckets: contract for the provision of services or contract for the provision of goods, where there are two sets of promises. One, the promise to deliver the service or the good, and the other one, the financial promise to pay. Now, typically, if you have included a force majeure clause in the contract, then the terms of those contracts prevail. If there is no force majeure clause, then we have in the contract that you're dealing with, then we have to look at the general law on the point. So I will request Poornima to quickly take us through the general principles and the under the Indian Contract Act, as well as about force majeure, before we discuss some of these clauses in detail. Poornima?
Thanks, Harish. I'm sure all of you would have known by now that force majeure literally translates into an act of God or a superior force. I noticed that we have questions coming in. We are taking note of them and we will answer them at the end. So please bear with us. And hopefully while we have this conversation, some of those questions may get answered. So going back to the contractual framework of force majeure, basically we have a situation where if there is a contract between two parties and they have intentionally agreed that there will be a force majeure clause, that means at the time of entering into the contract, you have actually discussed and thought about a situation where parties may not be able to carry out their obligation because of an external factor. And this external factor has to be strong enough, has to be of the nature such that the performance of the obligation will not be carried out. So it has to be something that is severe enough like that. So courts always construe force majeure clauses very, very strictly. I am presuming that after we have seen the COVID-19 situation behind us, there will be much litigation on the interpretation of various force majeure clauses. So the short point is, if you have a contract, you will have to read the provision in your contract on force majeure very, very strictly. This is the position both in Indian law as well as in English law in terms of common law. If you are looking externally to other contracts which have a non-common law jurisdiction, such as any European law or any Indonesian law, for instance, or specific states in the United States, then you will have to see how the interpretation of those laws arise. If your contract does not have a force majeure clause and is governed by Indian law, there is a principle called frustration. Now, what is the doctrine of frustration? It simply means that there are now certain sets of circumstances which could release the parties from performing their obligations. This means that no one saw a situation that is similar to the one that we are in. Now, we can argue that this is potentially a situation where parties did not look at a force majeure situation, where there would be a lockdown, where we would not be allowed to leave our houses, where construction workers cannot continue with work. So there is obviously a situation that parties did not look at. Traditionally, force majeure clauses have looked at in India in issues of riots, issues of fire, but an epidemic of this proportion has not been within the mind space of people when they've drafted the contract. So this is something that one looks at when we look at a doctrine of frustration. The Indian Contract Act, specifically under Section 56, has stipulated what constitutes the doctrine of frustration. This simply means, again, that which at the time when the contract was entered into, at that point of time, the contract was possible. There was no issue with it. It could have been performed. Now, because of a change in circumstances, there is a situation that the performance of the contract is impossible, right? So this has to be met. The condition is very, very strict. And only if this high bar is met, then we will say that it is now impossible because of these circumstances, and therefore the contract is frustrated. So there is much case law that has evolved. The Supreme Court has discussed this on many occasions. So the most recent Supreme Court decision, which celebrated the idea, which is celebrated for discussing frustration, simply says that change in prices or a very high escalation of prices, for instance, would not constitute force majeure or would not fall within the idea of frustration, simply because that is something that you could have foreseen, even though it may be of much higher. A change in law also often cannot be falling under this. So here we have a situation where an unprecedented lockdown, an epidemic, which has also resulted in government advisories, which could be argued as change in law. So all of this put together in the context of your own specific case, depending on the nature of the doctrine that you're looking at, could be argued to be force majeure. So I reiterate, there is very, very high bar. So that's what the doctrine of frustration is about under Section 56. I think we'll stop there, and Harish, you can carry on because we're getting a lot of questions. We should have time to address these as well.
Yeah, thanks, Poornima. I think I would like to add a few more points on contracts and avoiding the obligations on a contract before we go to the questions. Now, see, force majeure operates as an exception to a contract. So generally, once you enter into a contract, you have to be bound by it. It's a legally binding obligation. Force majeure essentially recognizes that sometimes there are circumstances beyond the control of the parties involved, which may prevent them or hinder them from performing their obligations. Now note, I'm using words very carefully because each of these words have different meanings and courts can interpret them differently. So prevent is a test, hinder is a test, mere inconvenience is another test. So all of these different categories of concepts that affect the performance of any obligation under a contract, not all of them are of a nature that can help you avoid the obligations you have undertaken in a contract. One thing Poornima mentioned already, and I can see some questions that people have raised, is that mere financial inconvenience. For example, just because the cost of performing is higher because it is difficult now to get that obligation done, has until now not been recognized as a force majeure clause in the contract. And typically, how force majeure clauses are drafted, mere inconvenience is not sufficient. There should actually be a circumstance or an event that prevents you from carrying out these obligations. So, for example, if your factory is shut and you are unable to manufacture the goods that need to be sent to your customer under the contract, then that is a force majeure clause. But mere shutting down of the factory, if you had some control over the shutting down, then it doesn't operate. But now, because there are government orders arising from the COVID-19 pandemic, therefore that could act as a force majeure. Now, my own view is that courts are likely to be slightly liberal when they're dealing with any disputes that arise out of the force majeure issues, in the COVID-19 situation. The reason is because in the last 100 years or so, I don't know from earlier, in the last 100 years or so, we have not seen such a widespread lockdown of economic and business activity across the world. I think there are very few places that are unaffected, and there are very few industries that are able to function as normal. But the question to ask for taking refuge under a force majeure clause is whether the lockdown or shutdown has prevented you from performing the obligation that you have undertaken to perform, and which obligation you are seeking to excuse yourself from. If the answer to that is yes, then you are likely to be able to take refuge under the force majeure. However, if the answer to that is no, it is difficult for me to do because the cost is going to be high, or it is not profitable for me to do this obligation anymore because I will actually lose money, or it is not convenient for me to do this because I have other things to do now. All of these excuses or categories of circumstances will not qualify as a force majeure. And it is important to remember this. So the impact, the adverse impact should be on the actual performance that you are seeking to excuse. And if such an impact can be shown, then you can seek a refuge under the force majeure clause. The second thing is how long. Now, typically, force majeure clauses also contain provisions which say that if you are affected by a force majeure clause, then you can only seek refuge under the force majeure for the period during which you are affected by the force majeure clause, not before or after. For example, to give you a simple example, the lockdown in India started about 5 days ago, but even before that, many of us had decided to implement work from home policies, either on the basis of loose advisories or in certain states on the basis of actual lockdowns. Like Maharashtra, I think lockdown earlier than India. Karnataka also started slightly earlier. Then mere precautions that you have taken are not necessarily sufficient circumstances to qualify as a force majeure event. This is what the law says. Now, are courts likely to interpret force majeure liberally in the context of the COVID-19? The answer is we don't know. Our own surmise is yes, they are likely to interpret it slightly more liberally than earlier because it is something that has affected everyone. For example, we were dealing with a client who has actually manufactured the goods that he has to deliver. It is ready and he is not actually being prevented from manufacturing it. But there is no logistics provider to deliver it to the customer who is in another country because nobody is operating. Now, while theoretically you can argue that you should make alternative arrangements even if it's expensive to get it delivered, there is a physical impossibility around that situation. So you cannot find new logistics providers because everybody has been prevented from operating. So that is something that may be excused. So these are some of the nuances that you should remember. Second, there is a difference between the lockdown of the economic activity and the actual pandemic. Now, if you take COVID-19 as a force majeure event, then in my view, it is much wider than just the lockdown. Because COVID-19 is something that affects all human beings. The risk is unknown. And, we don't know how it affects each human being. So we want to take more precautions. As against the actual lockdown measures suggested by the government. The lockdown measures may be directly creating situations where you're unable to perform the contract, but the overall COVID-19 epidemic or pandemic, as they're using, that is a much wider event which may or may not be able to give you refuge under the force majeure clause, because you need to show that you have to be directly affected by it, adversely affected by it. So the 3 points to take away from here is, if your contract has a force majeure clause, then please read that force majeure clause properly and understand it. And if you need to provide any notice to the counterparties under that force majeure clause, please take steps immediately. Don't assume that everybody is affected by COVID-19, so I don't need to send a notice. Typically, force majeure clauses say party who wants to rely on the force majeure clause needs to send out a notice describing the force majeure affecting him and how long he or she is likely to be affected. So you need to take the steps. Second point, inconvenience, unprofitability, high costs as a consequence of all this. All of these things are not typically covered under force majeure. Therefore, do not assume that you're covered. If you are not covered under force majeure, and if your contract is governed by Indian law, then as Poornima explained, there is a little window of opportunity under Indian law in terms of frustration of contract, which you can use, but it is a very high threshold. So that is on the contracts point. I know we have many questions on that, but I want to try and cover this premises, office premises, factory premises, and then we'll take questions one by one. So
sorry, I just wanted to add that once at the time when you're actually sending your force majeure notices or having conversations, we have noticed in the recent past, in the past 10 days, different industries want to use the word force majeure, some don't want to use the word force majeure. So under law, if you are actually invoking force majeure, it means the contract comes to an end. So the contract normally comes to an end either because it's performed or because there is a breach. And the third, more rarer situation is that of force majeure. So please document as much as possible. Find out the fact situation. What is the price? If you are going to sell something for 1 rupee and the cost now is 100 rupees, there may be a case that this is actually force majeure, although cost is not an issue, right? So cost is maybe, when you're looking at, if the cost becomes 2 rupees, then it may not be force majeure, but the cost is 100 rupees. Then if the nature of the business is small, you can well argue that this is a force majeure situation. So please keep a documentary record. If you are receiving notices of force majeure, please ask questions. What is the stage? Where are you at? What are the costs? What exactly has happened? If people are trying to just use words like disruption and not actually using the word force majeure, then please look at your contract and understand why this is being done. Because if force majeure is invoked, as I said, contract comes to an end. Whereas disruption may mean that there are certain aspects of the contract, particularly complex construction contracts, under regular rules of the FIDIC or otherwise, may have specific issues about who will bear these additional costs or what will happen. Please also note, once the contract comes to an end or the force majeure contract clause is invoked, this does not mean that the dispute resolution aspects of your contract, if there is an arbitration or if there's a mediation or if parties will go to court, those clauses continue to be valid. So you could, at the right point of time, even courts are right now closed. Whenever they do reopen, you do get the opportunity constitute your tribunals or approach court. So that part of the contract continues to be valid. Thank you. Harish, back to you.
Yeah, just to add one more point, the consequences of invoking a force majeure, and there are some questions around this in the, I saw in the Q&A and the webinar chat. The consequences of force majeure are different, and you can choose what they are depending on the nature of the contract, what the contract itself says, and the nature of the obligation that you're seeking to avoid. So you can either seek an extension of time for the period for which the force majeure is actually in place, or you can seek to terminate the contract. Again, there are two issues here. One, it depends on what your force majeure clause says. If your force majeure clause says either you terminate or perform, even if there is force majeure clause, then you don't have a choice. But your force majeure clause may also provide for an extension. If there is only termination provided and you want to seek extension, there is no choice but to talk to the counterparty and come to some sort of an understanding after explaining the force majeure event. But as Poornima said, keep records, send notices. These are all critical steps that you can take now. Do not worry too much about what are the consequences as of now, because to a large extent, all of us are dealing with an uncertain world. We don't know what is going to happen next week or on April 14th. In our country, we don't know what's going to happen in other countries. For example, if you're dealing with an Italian counterparty or a French counterparty, and you are the one who is suffering, then what is the planning that you can do? It's very little. I mean, you have to figure out what to do, and it is an uncertain world to that extent. But the only way we can protect ourselves is to keep records. Please consult your in-house legal counsel or a lawyer to review your force majeure clause and tell them and be advised properly before you take any steps or send any communication. The last point that we want to deal with is the relationship with your landlord. Is if you are working from a rented premises, whether it is office space or factory, can you say you won't be able to pay the rent for the time you are not occupying the office, or rather for the time you're not using the office? Because technically, and this is important, during this time, it's not as if you're given possession of the office back to the landlord. You're continuing to be in possession of the office. It is still under your control. So if you look at it, the landlord has not done anything that he's not supposed to do, unless he's asked any one of you to vacate the place, because if one of your employees is suspected of COVID, then if you have heard of circumstances when they've been asked to vacate the office. But other than that, there's really nothing that landlords can do to default in these circumstances. So as a tenant, can you say that you won't pay the rent? Again, it depends on what your lease deed or rental contract says. In my experience, there are very, very few contracts that include force majeure clauses when it comes to renting office premises. So it is extremely unlikely that you will be able to use the fact that you've been asked to shut down your operations because of COVID-19. It's very unlikely that you'll be able to avoid paying rent under the terms of the contract, unless your contract specifically says so. And this is also, it is also unlikely to be covered by frustration of the contract, because technically you want to be technically you are in possession of the office premises. It's not as if you have handed back possession to the landlord. Therefore, the paying rent is a sensitive issue and difficult issue, especially if you are the tenant. If you're the landlord, you're in a slightly better position, unless there is a force majeure clause in the contract already. Having said that, I know of people who have started sending notices to landlords asking, relying on the fact that COVID-19 is a force majeure, because we are all prevented from working from office, and therefore seeking exemption from payment of rent. Now, this is a bit of a uncharted territory when it comes to the law, and I think which way the courts will rule, we do not know at this point of time. But my suggestion would be that start a conversation with your landlords, because everybody needs, the situation is affecting everyone. A landlord who is your landlord may be a tenant somewhere else, or may have a business relationship with some other person, and everybody is being affected. And that's the uniqueness of this situation. This is not a force majeure clause that is affecting one or two individuals, and only those individuals are in difficulty. All of us, in some form or the other, are facing difficulties. So while we may want to invoke force majeure in one clause, in one contract, we may not want to invoke force majeure in another contract, because there it benefits us. So as businesses and organizations, we probably need to take a mature approach and look at each one in detail. So our first advice, at the sake of repetition, is go and relook at all your contracts, see which contracts don't have force majeure, see where it benefits you, see where it doesn't benefit you, and then we need to take a decision. Because it's very unlikely that you can take a position in one contract saying, I want to benefit from this, and in another contract where you have to actually pay to say that I won't pay because of force majeure, but in the second contract, you're saying no force majeure situation exists. So these are all tough questions for organizations and businesses, and they're questions that go beyond the law. Of course, the question in law will get reduced to the existence of force majeure and how it affected your ability to perform the obligation you had undertaken to. But beyond this, there are other issues. And as organizations, our suggestion would be to first review, as lawyers, first review the contracts in great detail and keep records. And second, take a view as an organization looking at all the issues. So when you're how you deal with your employees will also impact how you deal with your customers, because we're all living in a connected world. So you can't take inconsistent stands, because they can come back to haunt you in some form or the other. So we'll stop there. We will take more questions, or maybe answer some of the questions that people have raised. Poornima, you want to go first? Look at some, if you have had a chance to look at some of the questions.
Sure, I think there are a few questions which are asking us basically whether these advisories on not to fire employees and basically treat them as regular work situations, are they enforceable? I think it depends on each state. So if there is a specific mandatory language that is used, even though it may be called advisory, but if the language in the notification says this is what you must do or shall do, then they would be enforceable. I think we are seeing a lot of employer organizations correspond. It's still early days in terms of how it is, but before these advisories were issued, I think we've seen large airlines who've had their pay cut situation. People have asked people to go on unpaid leave. So I think that voluntary sort of discussion with your employees may be had, because that's not just one way. We've had situations where employees have agreed to work 3 days a week and accordingly take a revised payback. We've had situations where people who couldn't go to an overseas office be employed by their Indian entity here in India at the Indian salary level. So employees also understand. So if there are innovative ways you can look at it, please do. But the short answer is they may be called advisories, but the language could be a mandate. So please look if there are any industry specific ones. There are specific ones for construction workers, for example, specific advisories for the IT industry. So please look at what the advisory is saying insofar as your industry is concerned, and then you can act, but you can still have a conversation on folks voluntarily taking time off, and then that will help the organization. So I think a few of those questions are around that. If it's a mandatory one and if you violate it, I think you will be at the risk of at a later stage maybe some sort of government intervention or regulatory intervention. You also have the risk of your employee taking you to court, which may not be an immediate risk but a later risk. So that's something for you to consider if at that later stage you want to. But if there is a situation where it's the survival of the organization versus employing, 100 people, I think it will just be the financial situation that will actually work out. So this is where we are, or insofar as the employment situation is concerned. I think a lot of those questions were on employment law. May I request everybody to put your questions on the question answer tab? We're still getting questions also on the chat tab, so it's difficult to check where and what is happening. There are questions on rent, which I think Harish has answered, whether rent payments can be suspended and all of that. So question of that has already been answered by Harish. There's a question on cancellation of an event due to be held few months post the COVID-19 travel bans. Should the client be entitled to a partial refund? So in terms of specific questions like this, we need to obviously see the contract and see what the terms for refund were, what the terms, where your event is happening, and all of that. So we'll have to look at that. Harish, do you want to take a few while I go through some more?
Sure. I'll take a few. I think some anonymous attendee has asked, what is the impact on law firms? I think we're also evaluating. Let's see what happens. But just like everyone else, we are also affected by it, and we will be affected if our clients are affected. So we'll have to see how that goes. But there will be, law firms are also part of the same world. I'm sure they'll be affected in the same fashion as every other business. There's a question as to when does the timeline start? Can we say that it starts on day one of the lockdown to the time of ending of the lockdown, when you are not actually able to open your factory and therefore can't manufacture? That's a very safe view. In my view, that's a very safe position to take in my view. The actual shutdown, when you're not able to manufacture, is a good position to take. Then there are questions on companies laying off employees and there are no force majeure clauses. See, as we said earlier, force majeure clauses and employment in the companies are different. Now, typically employment contracts don't have force majeure clauses, but companies may lay off employees because their financial situation is bad. Now so your remedy there lies under labor laws and not under the force majeure issue. So you will need to consult a labor law expert on that. If you have specific circumstances, please reach out to us and we can take a look at that. There's a
There is
question.
one question, sorry, I'll take one
Sure.
or two more if I've had a chance to now look at it. There's one question specifically on the language used on the force majeure clause, and says that in the logistics space, it doesn't actually use the word pandemic. I think that is okay if it doesn't actually refer to the word pandemic. Most force majeure clauses will have a residuary language sort of thing, a catch-all provision which says that if this is not being able to be performed. So that's okay. If it still refers to epidemic, or even the fact that it doesn't refer to even an epidemic is fine, as far as there is something in your clause which prevents and protects a situation such as this, that is absolutely fine. And you can invoke that. Obviously, there is also a question which says, when can we say that this is not force majeure? We have enough e-commerce companies who are still functioning. So the government is allowing them to function. At least in Bangalore, we're still receiving, although there have been hindrances and sort of police excesses. But I think these are continuing to work. So in sort of those cases, yes, there is no force majeure. We are working as lawyers, even courts in situations of urgency are working. So it is industry specific in terms of what kind of provisions that you are looking at. Sort of movement of goods across the border and essential services are happening, but yes, pilferage, etc., stealing at the borders, those do not constitute force majeure. If there is stealing, you will have to obviously seek damages or look at what you would normally do if there is theft, but that would not fall within the four corners of force majeure. As we've discussed, it is a very, very high bar to invoke force majeure. Harish, you want to take any other situations?
Yeah, there are a couple which I can look at. Somebody is asking distinction between excusable delay and force majeure. Is one more terminal to the contract than the other? I mean, the answer is no. It depends on how each one has been defined. Excusable delay, if you ask me, is a much broader term than force majeure, and it depends on how your contract has been drafted. If it includes force majeure and plus other things, then fine. But is one more terminal than the other? No, it's not really that. I mean, as I said, it depends on the terms of the contract. Now, there's another question on, can I claim compensation for loss suffered? See, loss suffered, it depends on who you are. I mean, if you cannot accept certain goods, can you claim? The question there was a bit confusing, so I don't. The question is, oh, my contractor keeps producing the goods, but I'm not able to accept. I don't understand. I think there's some confusion there in the question, but answering broadly, loss suffered is not an excuse or does not constitute force majeure in itself, as we discussed earlier. Just because it's more expensive for you, it's not good enough. But if you're asking whether because the other party has suffered a force majeure event and you can claim some compensation, that again depends on what the force majeure clause is and what you have agreed with your counterparty in the contract. Impact on lenders, loan repayments. Can borrowers take this opportunity to extend beyond the moratorium provided by the RBI? Again, the answer is no, unless there is something in your contract. And typically, loan agreements don't have these kind of clauses. But if your loan agreement does contain a clause like this, then there may be some possibilities there. But it's not, as I said, it's not very common for force majeure clauses to be invoked in a loan agreement. Is there any scope for claiming frustration only for a limited period of time? See, the answer is yes and no, but as Poornima explained earlier, the threshold is very high, and you need to have the ability to show that you are directly affected. Somebody is referring to agreements for lease for provision of co-working spaces. As I said, provision of office spaces is something that is normally generally not covered by force majeure clause or even frustration, because as I said, you are in possession of the office premise as such. It depends on how somebody saying co-working spaces. It really depends on how your contract in the co-working space is worded. Is it based on use? Is it based on time? It depends on how it is worded. There's a question on an international contract. It does not contain epidemic, but the other party has denied it. Listen, I can't really answer specific questions unless we see the contract. It's very, very difficult. Government orders imposing ban on human and material movement, including lockdown, does it fall as force majeure? My answer is yes, it should act as force majeure. To give you an example, right now, there are some. If you look at large construction contracts, large project contracts, the force majeure clauses run into pages. There are 5-6 pages of force majeure clauses. It is not the 1 paragraph or 2 paragraphs that you see in regular contracts, right? So for some lawyers, particularly for construction contracts and project lawyers, force majeure is a work of art, right? So some of the questions that you're asking has actually been tested, and each clause in the force majeure is worded in such a way to cover some of these questions. For example, if there's ban on human and material movement, lockdown, does it force majeure? It is included. But if the ban is something that you have created on your own, for example, you are the government also and you impose a ban on human and material movement, then you may not be able to benefit. Increase of cost of raw materials is not typically in a force majeure clause anymore. So these are all clauses and circumstances that have been tested in different parts of the world, including India. And therefore, in large contracts, the force majeure clause is defined very, very precisely and written very, very precisely. So it's very difficult for me to answer some of these specific questions. But overall, so what I will do is, instead of trying to answer specific questions, I will say what we think can happen in the current scenario. So as I mentioned, for those of you who joined late, and for those of you who were here, but at the sake of repetition, COVID-19 pandemic, is it a force majeure? The answer is it is force majeure. But whether it is force majeure for your contract, I won't know until I see your contract, right? Unfortunately, that's how the force majeure clause works. While overall scenario in the world is that it is a big disruptive event, whether it helps you excuse your contractual obligation is something that we have to examine. There is no one single answer to all these questions, correct? Therefore, the first point I would like to make is COVID-19 pandemic is a disruptive event. It probably will constitute force majeure in majority of the contracts in the world, but whether it will excuse all your obligations is something we have to check. There may be contracts which may not be excused by COVID-19 pandemic also, because the performance of your contract may not have been adversely affected at all. So then we have to examine if it is not affected or affected. That becomes a question of fact that has to be evaluated by arbitrators or courts. So we have to go back to the fact situation. Third, what is the benefit or otherwise that you can get out of this force majeure clause? Some people have asked, refer to the RBI moratorium. Some people have referred to something else. Now, each of these are very specific and cannot be cannot be collated or clubbed in under one heading. Each of them have to be looked at in isolation. The third point I would like to make is confusing the actual impediment that you face in performing your obligation with other events prior to the beginning of this force majeure or after the beginning of the force majeure is very, very difficult. You can't mix it. Force majeure is very specific. You have to show that there has been a clear disruptive force for your business. For example, in China, the COVID-19 pandemic started a long time ago. Wuhan city was shut down. Now, you can't say sitting in Bangalore that I was not able to perform because COVID-19 started at that time. It is not possible to do so. So, how it applies to each of your individual organizations, each of your individual fact circumstances, unfortunately has to be reviewed independently and answered independently. There is no one silver bullet answer. Let me stop, Poornima. If you have gone through any other questions and want to add anything, please do.
Thanks. I cannot stress as a litigating lawyer how important it is for you to document. If you are unable to perform something today, your clause, but if you see your obligation under a contract under some sort of restriction, please begin to write to the other party. You cannot wait 2-3 months and then say this is what has happened, simply because all parties have the right to mitigate. So if I know I am not going to get something, then I, as the other side, have to begin to take steps to ensure that the damage that I will suffer is limited. And I can only do that if the other party communicates to me. So please begin to communicate, even though it may not be technical. At least begin to send out emails to say this is what has happened. These are the reasons why we're reviewing the situation. What is your suggestion? What else can you look at? So this is also very important. So the question was, is there a waiting period? No, there is no waiting period. There are questions on whether frustration as a doctrine can be invoked under Section 56, despite having a force majeure clause. We have seen enough case law where they have been argued hand in hand, but both of them have a high bar. So if you could argue force majeure, I think whatever relief you will be able to get will be the same relief that you will be able to get under Section 56. Section 56, as a doctrine of frustration, really is for people who don't have a force majeure clause, but I don't see any harm in arguing that. There is a question here also where somebody is saying that their company is already laying off employees and there is no force majeure clause in their employment contract. Indian employment contracts, as we've discussed, normally don't have force majeure clause, and this is even up to promoter level, senior management level, whereas we've seen these clauses internationally. If there is no force majeure clause in your contract, please ask your company, why this is happening. Despite the advisories, companies may not have deep pockets and simply may not have the ability to pay. But most employee contracts, where they're non-workmen, will have a clause which says that if somebody pays you in lieu of a month or 2 months, depending on how senior you are, it can go up to 6 months. And so if they decide that they're going to just take stock of the situation, pay a lot of their employees a month's salary, and then terminate you, and if that is contractually allowed, well, then that is what it is. If they are workman category of people, then there has to be a reasoned retrenchment guideline that is under the Industrial Disputes Act that has to be followed, and there has to be consultations depending on how large the workforce is and whether unions are involved. So that is a fairly more complex situation. And again, there are state-wide stipulation industrial standing orders come into play. So yes, there are different scenarios depending on what kind of employee you are and what kind of organization there is. There are questions on insurance and whether insurance can be invoked. Again, this is a complex area. If your insurance covers force majeure situations, and we've seen it typically in the case of fire, particularly in industries which are prone to having fire, insurance has covered force majeure situations. Insurance companies are very astute to the idea of force majeure. In the case of your insurance contract, please examine whether non-performance due to force majeure, such as a pandemic or epidemic or an outbreak of disease, can be covered. Then yes, you will be able to ensure that the insurance coverage is already in play. Please again begin to have conversations with your insurance companies so that again a delay is not interpreted as you having sat on your rights and not acted. So that's something that you can begin to look at. In the SARS epidemic period in Hong Kong, as well as in some parts of China and Singapore, there was a very different kind of insurance product that emerged because it was over a period of time with high premiums, where I have not seen anything that has emerged in India in this context from insurance companies. But if you want to have that discussion, it's worth having that conversation with insurance companies to see if they will protect you. I'm presuming the premiums will be quite high in that, but they seem to have worked in the SARS situation in Singapore and in Hong Kong. So those are the insurance questions. I think there were quite a few on that. I am beginning to look at a few more. If COVID-19 is covered under force majeure, earlier breaches of the employer, delayed projects, etc., can there be compensation? Yes, force majeure is triggered from the time when actual performance becomes impossible. So that's the reason why we keep stressing, saying the moment, I mean, just imagine, this is from a few years ago, we had a case where a large ship caught fire and everything on the ship burnt down. And there was an obligation on the parties to communicate immediately if there was such a force majeure situation. So the time the ship got fire and 24 hours down, when it was clear that no obligation could be performed, is your force majeure situation. So if your factory is shut down, or if you cannot do something immediately, either by law or by circumstances, that's when your force majeure situation gets triggered. Any earlier breaches, delays, etc., will be outside your force majeure claim and will be governed by the general terms of the contract for which you have rights in law, as you would normally do. So please make sure that there are different distinct sections that are here. The lockdown, yes, is under the Disaster Management Act. There is a comment on the same. And the Disaster Management Act, as I discussed earlier, requires different ministries and departments to make sure that there are advisory issued. The Disaster Management Act and the Epidemic Diseases Act have fairly wide powers for the state and the center. And we can see whether this kind of government action could be seen as a change in law. And if that is a change in law, and if your force majeure clause covers a change in law, yes, you could invoke those. If they don't, yes, you'll have to look at how you compute or claim damages accordingly. So those are a few questions on that. We have questions on business parks, and we want to understand the force majeure that may be given by tenants. I think Harish has already discussed this.
Yeah, Poornima, there are two questions that I've looked at, which I think are interesting. One, whether an arbitration in an international arbitration can read into the implied force majeure clause in a contract. No, you can't read force majeure in a contract. Unfortunately, it has to be specifically
mentioned. Can I just stress there that force majeure by nature cannot be an implied clause. It has to be explicit. It is very detailed, and only then it can work. If it is implied, then we're looking at the realm of frustration, because otherwise it wouldn't really work. Sorry, Harish.
Yeah, good clarification. Thank you. I think in addition to that, what I would like to stress is India is slightly different from other common law countries because we have a contract act. So if the contract does not have anything on force majeure, then you have the ability to rely on Section 56. Whereas in other common law countries, you can't rely on any law if the contract does not contain anything. And it's different in civil law countries because you will be governed by the general code of contracts, and there may be provisions in those codes which will help you. So it depends on which country the contract, which country's law the contract is governed by. There's a question which says, can I invoke force majeure to suspend payments to vendors since the company has no visibility of receivables with sales come to a standstill? The answer is unfortunately no. Your general financial situation arising out of this event will not typically constitute force majeure. I think we have probably covered most of the questions. Idling losses, stoppage of works, unfortunately, no, you cannot claim damages for that. Unless your contract, in some construction contracts, there are clauses which allow for these claims, but it depends again on what the contractor, the main contractor or the main developer, principal, depends on whether he is going to depend on a force majeure clause in the contract, which also will come into play. So we need to look at that. So it's not that simple where you can just claim idling costs as losses.
I agree, Harish. I think we have covered most questions. They seem to be otherwise related to each other. If you have any other questions,
I think there's a question on whether contract termination can be given by email or not. I mean, listen, yes. I mean, it's really something that you should, it depends on what the notice clause says. Generally, under Indian law, if you're able to show that the email was sent properly, it's possible to send termination notices, but it's a question of proof and evidence. But the answer is broadly yes, subject to what your contract says.
There is no limitation on communication at this period. It would be difficult to argue that you don't have email or internet or didn't have knowledge of what was happening. So please do communicate. We've seen this defense taken, but I think this day and age, as it shows that we're all logged into a webinar from different places, you do have access, so please do communicate and ask for information if you don't have information. If information is not forthcoming, then you can, obviously there are no inspections of sites or inspections of samples that could happen. But use whatever access you have in terms of technology to understand the facts, because that will later have a bearing on what damages or what obligations and what claims will be laid between parties, if at all. Any other questions?
I think we have answered most questions, Poornima. I think listen, I understand that some of you may feel that some of these questions are different from what we have answered, but the peculiarity of facts is something that we cannot cover on this call. I mean, we need to be able to examine that, and whether the contracts or lease deeds or your specific document that you are governed by, what does it say? So we need to look at that in particular. But those are fact specific, and we will have to examine that when you send us details and ask us proper questions in terms of those particular contracts. But generally, I think we have covered most of the questions broadly.
So if you are in doubt, please seek advice, because what you do at this time will determine later in terms of your claim and damages. And as Harish said, it's difficult to give general advice without seeing your contract, particularly if you see a large amount of damages that may arise. Look at it. If you're invoking standard forms of contracts in construction contracts or other guidance contracts, you may have some guidance from those institutions themselves. But otherwise, please do seek legal advice.
Okay, so thank you everyone for joining and participating in the webinar. Obviously, we will get more insights over the next few weeks and months about the situation overall and how it affects each of our organizations. So please feel free to reach out to us if there are any specific questions related to your own contracts, and we are happy to examine and look at it. But broadly, these are the rules that you should keep in mind. And as Poornima mentioned, I would like to end by stressing what she's said. Please document everything carefully. Please review the contracts immediately, and all the best to all of you, to all of us actually.
Thank you, and everybody stay safe and stay at home. And please do write in if you have any other questions. Thank you very much.